The Arizona Center for Disability Law. Differences in protections for students with IEPs, 504 plans, or no documented disability. School discipline protections change depending on whether or not the school knew the student had a disability when the misconduct occurred, and if so, whether the student has an individualized education program, or IEP, or a 504 plan. Let's begin with students who have IEPs. If a school wants to long-term suspend or expel a student with an IEP, the school must hold a meeting called a Manifestation Determination Review, or MDR, within 10 school days of the decision to discipline the student. At the MDR, members of the child's IEP team determine whether the student's misconduct was a result of the student's disability. If the MDR determines the misconduct was a result of the student's disability, the school cannot move forward with disciplining the child, and the child must be allowed to go back to school. If the MDR determines that the student's behavior was not a manifestation of the student's disability, the suspension or expulsion can proceed. It is important to know that even if the MDR determines the behavior was not a manifestation of the student's disability, the school must still provide the student with all of their IEP services during the disciplinary period, even if it is in a different environment than their usual school or classroom. What about students who have 504 plans? Students with 504 plans have the same protections as students with IEPs, with one important difference. If the MDR determines that the misconduct of a student with a 504 plan was not a manifestation of the student's disability, then the student can be long-term suspended or expelled without access to any special education or related services. What about students who may have a disability but do not have an IEP or 504 plan? The MDR protections described above can apply to students who do not have an IEP or 504 plan if the school had knowledge that the student had a disability before the behavior took place. A student or parent can prove that a school had knowledge of the disability 3 different ways. 1. The parent expressed concern in writing to the school that the student was in need of special education and related services. 2. The parent requested an evaluation of the student for special education eligibility. Or 3. A teacher or other school staff expressed specific concerns about a pattern of behavior demonstrated by the student to school leaders. However, the school is not considered to have had knowledge of the child's disability if the parent or the child refused to consent to an evaluation of the child in the past, or if an evaluation has been conducted and the child was found not to have a disability. If a child without an IEP or 504 plan is facing school discipline, and the parent is unable to prove the school had knowledge of the child's disability before the bad behavior occurred, the student or parent can ask the school to conduct an expedited evaluation of the student. This means that the evaluation should be conducted as quickly as possible in order to determine if the student has an eligible disability. If a child does not have an IEP or 504 plan, the school is not required to provide the child with educational services during their disciplinary removal. For additional information and resources about school discipline of students with disabilities, please visit ACDL's website at azdisabilitylaw.org. Funding for this video provided by the Arizona Developmental Disabilities Planning Council.